Alright, I'm about to show y'all these rules of court real quick. It's a lot of stuff to go over, so I'll try to break it down piece by piece. But we're not gonna go over this whole thing. It's a lot of stuff in here, as you can see. Hold on, what's that? Okay. This new tech. Okay. Um, yeah, I gotta get used to using this. But look, there's a lot of stuff in here, and this is the New Jersey courts.gov. Right here, they got a lot of stuff in here. Forms and execution of papers. That's something we got to look at. Jury subpoenas, disqualification code of ethics. Look, practice of attorneys, judges and court personnel, duty of judges, judicial advisory committee, arbitration, members of the bar, bar examination, Mr. the law, New Jersey Lawyers Fund for client protection, lawyers trust accounts, court schedules, court business, administrative. It's a lot of stuff in here. Who may appeal, time for appeal. Something I want to show y'all real quick. It's going to be one video of many videos I'm going to do. Going through these court rules with you. But you got to know, because you can't just read one part and then think you know everything. You got to read this part, then this part going to take you to that part, and that part going to tell you look over here. Then on top of that, you got to know the meaning of these words. All right? Because these words, a word in the law doesn't necessarily have the same meaning that it has as people use it in everyday lingo. So right here, as I showed you the part where he talking about counsel, the grand jury, he talking to the judge or before the committed judge. This part right here in particular says the defendant's obligation to provide notice. It doesn't say the lawyers. It doesn't say the judges. It says this is the defendant's obligation. You're obliged to provide notice. Notice under specific criminal code provisions, right? And what is this? This is a defendant shall serve written notice. Notice, it says written. Written notice. Feel me? On the prosecutor if the defendant intends to rely on any of the following sections of the Code of Criminal Justice. Right? Oh, I didn't mean to do that. Let me get that pen out of there. I gotta get used to this. It's tricky. It gets tricky now. Hold up. So this is dealing with defenses, right? And this is in a 2C, and we'll take a look at that in a second. But I want to show you, right? The first thing is ignorance or mistake. That's funny, because we'll get into these like individually, but I just want you to look at it overall. Accomplice, renunciation, terminating, complicity, intoxication, duress, entrapment. Everybody knows a little thing about entrapment, but you got to read it as they wrote it. General principles of justification, things like insanity. We all heard the plea of insanity. Lack of a requisite state of mind, criminal intent, renunciation of criminal purpose, conspiracy, renunciation of criminal purpose, murder, affirmative defense, felony murder, criminal restraint, theft by extortion, perjury, retraction, false swearing retraction, controlled dangerous substance near or on school property, and distributing, dispensing, or possessing controlled dangerous substances within 500 feet of public housing facilities, parks, or buildings. No later than 7 days before the initial case disposition conference that is scheduled pursuant to Rule 39-1E, defendant shall serve on the prosecutor a notice of intention to claim any of the defenses listed herein. And if defendant requests or has received discovery pursuant yada yada yada, the prosecutor shall within 14 days after receipt of such discovery comply with Rule 313-3B1 NF with respect to any defense for which the prosecutor received notice. For good cause shown, the court may extend the time of service in. Pardon me, I'm adding words and stuff. May extend the time of service of any of the foregoing and make such other orders as the interest of justice requires. If a party fails to comply with this rule, the court may take action as the interest of justice require. The action taken may include refusing to allow the party in default to present witnesses in support or in opposition of that defense at the trial, or to allow the granting of an adjournment or delay during trial the interest of justice demands. So these are, the effects of someone going into default in a court case, and if you're dealing with the defendant and the opposing counsel, who's the prosecutor, right? So that's that.